Hi, this is Stacy Summeter, and I am hosting the show How to Fight CPS and Win from New York State, the New York edition. My claim to fame is that I divorced an attorney who formerly worked for Child Protective Services. Our divorce spanned 10 years, was long and contentious, and basically any obstacle or hurdle that you could experience has happened to me, but also has happened to our very special guest today, Catherine Kazanoff, who herself is also an attorney who also divorced an attorney. Um, so she's here to tell her special story today about some involvement with CPS and their actions that don't make sense, and as well as not only CPS with bizarre responses to certain concerning actions, but also the family courts that follow through and also don't respond appropriately to very dire situations. Catherine, would you like to explain some background about your involvement with CPS and some of your experience in court and trying to protect your children?
Sure. Thank you, Stacey. I just want to say thank you for inviting me onto your show. I um, wasn't expecting that I was going to be joining you today, but I'm thrilled to do it and to offer what little or great advice that I can from the experience of my own story. I know that I'm not alone in what I'm about to tell you, and hopefully this can help other people and maybe even my own children. But to make a long story short, I am a lawyer, um, and I was married to a lawyer for 13 years. And we had a difficult marriage. In January of 2021, I have three children, three girls. In January 2021, my oldest daughter decided, after she had been living with her father, who had gotten temporary custody for some time, that she did not want to be with him. And she, in the middle of the day, well, actually, it was shortly before school started, um, left her household with him. And I was living in a neighboring town, and she took a taxi at age 11. Um, when she showed up at my door that morning, I was shocked, and I because of her courage. I wasn't shocked because of what she had to say. I was shocked that she had the courage, and it made me realize how bad things were for her.
That
That
is some serious intent for an 11-year-old to plan an escape and get into a taxi cab. And do you live in a large city where you're from, or?
I'm in Westchester County. We have lots of little villages that are kind of nearby each other. So I was about 10, 15 minutes away by taxi. And she took a chance because she was desperate. And unfortunately, it didn't end well because she showed up at my house and she thought, this is great. I get to stay with my mom. I don't want to go back there. I'm miserable there. I won't go into all the details for various reasons, but she was not safe there in her mind and in many other people's minds, including my own. She wanted desperately to stay. Unfortunately, I was required to call her lawyer. That was the first thing I was required to do. And her lawyer, who ultimately was removed from the case, and I'll talk a little bit about why that's an important step. Her lawyer basically shut her down and said, "You've got to go back to your dad. I don't know what you're doing there. You can't stay with her." Um, and basically coerced my daughter into going back to her a miserable household. And she fought it. She recorded the phone call she had with her attorney, and she explained to her lawyer, I'm being abused in this home. I don't want to go back. I want to stay with my mom." And this lawyer basically said to her, "Well, that was a long time ago. So, unfortunately for you, you do need to go back." And my daughter pled with her and pled with her and said, "What can you do?" And she basically said, "Nothing. There's nothing I'm going to do for you." And then I was instructed to send my daughter back. But before that happened, CPS came to the house and they interviewed me. They interviewed my daughter, and they would not take a position to protect her. They basically said, "Well, we'll take this under investigation and we'll go interview the father and we'll interview other people. But yeah, for the meantime, you do need to send her back." That was their And to make another long story short, it happened again. It happened
Sorry, I was trying to look up something for you, Catherine.
That's
Um,
okay.
and it
If you
keeps
have
going
questions.
to, yeah, so that we're
Yeah.
double. But there's a couple of things I wanted to let you know here. So, running away was in my situation as well. My daughter ran away several times, many times involving police reports,
Yeah.
and police to go actually find her. So she actually went missing and didn't even show up at doorsteps sometimes. And sometimes she did. Sometimes she showed up at my 90-some-year-old grandmother's house. Sometimes she showed up at my parents' house. And my house was just a little bit further. She never went in a taxi cab. Um, but um, she was complaining at the time of being strangulated by her father. And every time they sent my daughter back to her father's house, she ran away so many times she was hospitalized to figure out why she was running away. And she even disclosed then that he was strangulating her, that he was restraining her in a way, putting his knee or his foot into her back or her stomach. And they still sent her home to her father's house. So your situation, brings back, some of these issues that I went through too. And so I'm sure you looked into this. I looked into this because that's our nature to start, looking into the research on running away, what CPS knows about running away. And there's a few things I want to tell you. First of all, I did depose our CPS worker who ignored my daughter's running away. And when I deposed her, in her name, or I guess we can't really say names, but she worked for Niagara County CPS in New York, and we deposed her August 2017. Okay, so we're both New York State. Our CPS people, should be getting similar training. And she admitted, usually, when she was asked, do you know why children run away? Her answer was usually because of problems in their home. And there's a couple other things. There's a case, and I'm not sure how to spell her name correctly, but there's a case of Acacia Mosley, I think it was Mosey. It's spelled something like Acasea, but I could be totally spelling it wrong. But this was a case of a disabled individual that kept running away from an abusive home. And she ran away so many times, and every single time they sent her back to the same place she was running away from, and she died. And the state is being sued and CPS is being sued. Well, I guess it was APS, or I'm not sure if she was an adult with a disability or what have you. They're being sued for improper training, failure to recognize what running away means. When my child was running away, I also went to the National Runaway Safe Line, and there they have a lot of information, forums, and things to teach you about what to do if your child is prone to running away, like putting your phone number inside their sneaker, some things like that. Because if they get in a situation, they forget everyone's phone number because we all just hit dial mom these days. Some advice like that. But it is well known by these people, make no mistake, because I deposed a CPS caseworker because they get sued for doing things like this, because this is what the research says. The research says kids don't run away because they're problems. Kids run away because there's a problem in the home. Sometimes if they're the LGBTQ, that sort of situation, and they're not comfortable, and maybe they feel not, accepted in their home, or there's a pregnancy and they don't feel accepted. But the other reasons, it's primarily abuse why they run away. And these people, they know it. So this is what they did to your child. They
And
sent your child back to the place she was running away from.
and to your point, Stacy, when I raised this the very next day in court, her lawyer and even the court itself tried to mischaracterize the runaway. They tried to make it sound as if my daughter was a truant and that she didn't want to go to school.
Right.
This is a child who, she's got, oh, she can't go to school. This is terrible. Um, and it was the first time I really felt kind of like shocked by the court. And I kept saying, no, that's not what this is. This is a child who misses her mother and who's in a really bad household right now and doesn't want to be there. She's miserable and she has really good reasons for not wanting to be there. And in response, her own lawyer, Carol Most, said, this child needs to go to a therapeutic boarding school and a wilderness camp. And we spent the next hour trying to convince the court that this is not the appropriate choice for my daughter and that CPS really needs to stand up and do a full-fledged investigation and find out what it is that she's complaining about. And it was never done. And
Yeah.
court
The old, like, if you watch old movies, right? They sensationalize running away and a kid looking for an adventure, or they put it in the old movies. They kind of did put it on the child, but that's not what current research shows anymore.
And yeah, I suppose you're right, Stacey. I will tell you that was not my daughter's, reasoning. She did not have behavioral issues. She was not unhappy in her school. She was regularly attending, but
Right.
she did not want to stay in that household. And she wanted her mom. She'd been deprived of a lot of time with me. And the court, unfortunately, my story pretty well at this point, but was not interested in that narrative and was very disingenuous in the way that it was accepting the narrative that was being presented to it, which was, oh, this kid has behavioral problems. Well, fortunately, we were able to show that that was not the issue. But unfortunately for my daughter, she did not get out of that household. The thing that really helped me in the end was not trying to pursue, CPS and bring a case. And I applaud you for that. I know that's a big deal. I went in a different direction. Um, I took issue with her attorney. And because I had a recording, because I had other evidence of this attorney's suppression of domestic abuse and her inability to do her job and to advocate on behalf of my daughter, I was able to remove her from my case.
And you're
And
lucky. You're lucky for that, because my case, my children, okay, their attorney for children used to hire my ex as an attorney to do work for him for over a decade. And my kids disclosed sex abuse to their attorney for children. And he continued to argue custody to the father. And when I tried to have him removed, the court did the see no evil, hear no evil, speak no evil, that the attorney for children hiring my ex was not a conflict of interest.
wow, that's shocking.
So it's like these CPS actors, because they're not really protecting children, they're just actors, right? Work hand in hand with the courts and the attorney for children, and they all, scheme together. Because when you have a child that's running away and identifying abuse issues and goes to the extent of hailing a taxi to get to you, that's so significant.
Well, you're right, but to your other point, they only really kind of win this if they have safety in numbers. I mean, if they are sort of a standalone person saying, "Oh, there's no abuse here," or "There's, everything's just fine," they lose credibility. So it only really works when CPS aligns itself with the attorney for the children, with the father's attorney, with whoever, the therapist, whoever else. And
Right.
that's when it works. And that's why it gets so hard to combat. And then what happens, I think, in response, and I'm sure a lot of moms on this call can sympathize with this one, now you're picking a fight with not just CPS, but you're picking a fight with the AFC, you're picking a fight with the therapist, you're picking a fight with the court and with the attorney for your ex. Now suddenly you're labeled as a lunatic, basically, because you're now a conspiracy theorist. But it is purposeful that they set it up in that way so that you do appear to be just that.
So that's what I tell people. It's a line that I use often. is that conflict of interest can exist without corruption. So that means, if you hired your sister to work in your law firm or something and there was some conflict, she could do the right thing. You could do the right thing, even though that conflict is kind of there. But corruption cannot exist without conflict of interest. And so that's what you're describing, right? So
Yeah,
it's
yeah.
it's 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 pervasive conflict of interest. They all try to hide the conflict, so it's our duty to scour everywhere to find where the conflict lies. um, but yeah, that's what it is they are all working hand in hand. They all know the conflict and they're working together, because yeah, stand alone they can't do it.
The thing that prevailed in the end for me, and I'll just share this, hopefully it can help other people, but there's a little known rule that applies to attorneys, the ethics of attorneys in New York State and elsewhere, and it's called the witness advocate rule. And this rule basically means that an attorney, meaning an attorney for the kids, cannot act both as attorney and as witness within the same case, right? And what happened in my case was just that the attorney for the children, for all three of my children, was their attorney, but then became kind of an attack dog witness against me in court. And she would use hearsay and she would go into court and just start reciting what she purported to be facts. And it became overwhelming and very clear that she was in violation of the witness advocate rule. So when I got enough of a record together on that point, I made a motion, and my motion was to disqualify her. And I was lucky that I had a judge who really understood that rule well, and she did disqualify her. She not only disqualified her, but denied her all her fees for a whole entire year. Um, but that I wasn't expecting that kind of a win. And I would just say to people on this call, look at the witness advocate rule. If you think your AFC is taking strident positions against you based on a record that is not in the record, hearsay evidence, try to see if you can make that kind of a motion.
Well, you'll be happy to hear that in March, we appeared in court, and the attorney for children admitted to the judge that my kids don't like him and don't want him to be the attorney for children.
Oh,
So uh,
is
that
that
might
what
be
you
because my kids are actually saying he goes to court and lies about their wishes.
yeah.
But so he is off the case, but it took 10 years to get him off the case and all the damage he's done.
Yeah. Yeah.
So um, so CPS unfounded anything then with your daughter's runaway. Nobody psychologically explored her. They made all these allegations that this is a behavioral issue and so forth. But when they found it wasn't a behavioral issue, nobody psychologically explored her, interviewed her to find out why she was running away once they determined it wasn't a behavioral issue. Like, how does that
So
go?
that's a really, really good question. So what happened was, because I was the non-custodial parent, I was not made privy to a lot of what they did. So I'm not, as I sit here today, I'm not able to tell you exactly who they interviewed, where they interviewed my daughter. Was my husband sitting next to my daughter when they interviewed her, right? And the court also kind of had a really sinister role in all this, because the court did what's called a court-ordered investigation. And that's when the court will basically commission CPS to undertake an investigation and report directly to the court rather than through its regular processes. So the court did that. And the results of that investigation were never really shared with anybody. I believe it was all considered unfounded. Um, I, but to this day, I really couldn't tell you
Have you ever
how.
tried to get the records?
Um, I did not. And one of the reasons I didn't do that is I thought that we stood a better chance in court rather than fighting through the CPS processes. In the end, I was right, but not initially. It took me years to do it. But You're right. I mean, there are records. I don't know that they make those available though, even to a non-custodial parent. I'm not sure.
Yeah, they do. But I'm not sure. Yeah, I've gotten mine. And my ex has 4 CPS indications, as you know. Um, but they also sent the unfounded ones when I did call the state register. So maybe try and call them and see if you can still get those. As a parent, you should have that right. I
Yeah.
can, yeah,
Yeah, it's a good idea.
ultimately. Wouldn't that be something if they came back, found it, and everybody hid that from you?
Well, then, what was really upsetting, of course, is that it happened, like you said, it's usually not a one-time incident. It did happen again. My daughter ran away again in the same fashion, you know, in the morning, took a taxi, showed up at my house. And when she left, it was horrendous circumstances because she refused to leave that time. So the police were called to try to make her leave.
Yes, right. This happened too. I get it.
And she was hyperventilating, saying, I won't do it. She was refusing. Ultimately, they brought an ambulance to my house
Same thing.
and they told her she had to get in the ambulance, she had to be psychiatrically evaluated, and that I was not permitted to go in the ambulance with her to the hospital. And I mean, I couldn't believe what I was being told. And CPS was just, CPS was just sort of like standing there. They seemed to have very little role once the police came. Um, and then she again was evaluated and then released to her father.
I don't know if I should be proud of my child or not or what.
But
But they stuffed her in the back of a police car and she Houdini'd out. But
wow.
when she did that, they called an ambulance and they put her, it was technically 5-point restraints. And they restrained her in the ambulance and they took her to be psychiatrically evaluated while she was running away. When
That's
she
the
got,
part that I find so disgusting, right? That a child is now viewed as psychiatrically, questionable because the child is running away to her mother's house. Does that make any sense? That's not a psychiatric emergency. That's a kid who wants to see her mother.
right. And so they took my daughter to the hospital by ambulance. They did allow me to go with her, but it was super traumatic because to put a child in 5-point restraints who's been complaining of being strangulated by her father
Yeah.
is very traumatic. So she got to the hospital and she made all these disclosures, and the nurse reported them to CPS. And she made disclosures that he was squishing her, he was putting his knee into her abdomen, that it hurt her, that she couldn't, it stopped her from breathing, that he was threatening her if she told what was going on, he was going to hurt someone. And she made these disclosures. She said she can't even sleep at his house because of the things he says to her that bother her. The nurse from the hospital dutifully reported this to CPS, but my ex worked for CPS formerly. So what happened when Niagara County CPS got that report, they closed it as a duplicate, even though it wasn't a duplicate report. And they never investigated it, and they allowed her to be discharged from the hospital back to her father.
This raises, of course, the whole issue of what can you do against CPS, and maybe you have a whole segment on that, Stacy. I mean, I don't. I worry, of course, about the immunity that applies to lawsuits against them because they're, government workers and they have either quasi or absolute immunity
They have
for the
qualified. Yep.
qualified immunity, which is, it's still hard to break that immunity. And I don't see a lot of cases out there where that's been successful. I'd love to see, people who've been successful. And I don't know if you're planning to do a segment on that, but I'm sure people would want to hear that.
Yeah, yeah. So tell us some more about your case, because there's so many moving pieces, and you work very hard on your case. Um, what happened this Mother's Day?
Yeah, I mean, I'll just say one more thing about it, which is that, their kids, they're initially, I think a protective parent, right, thinks, "Oh, my duty is to protect. My duty is to call CPS if I think that something's going wrong, and to have them investigate." And you put your faith in what you think to be people who with good intentions. What you don't prepare yourself for necessarily is that if your allegation or your inquiry or whatever you want to call it becomes unfounded, which is more often than not, frankly, in a lot of these cases, you're then viewed as suspicious, or worse, you're viewed as making things up. You're viewed as, and this can affect your custody, right? This can affect your ability to argue for custody, because if you have repeated uh, complaints to CPS and CPS keeps deeming them unfounded, you're going to be viewed as unreliable, crazy, whatever the word is.
That
And
that
so,
that actually happened to me in custody trial at the time. All of the allegations against my ex were unfounded by his own people that he worked for, and the judge denied me custody because he was upset that I had these allegations against my ex and they were unfounded. And he ruled I was crazy to believe, irrational to believe, the abuse occurred despite their unfounding their own employee. And shortly after that ruling, of course, he was indicated 4 times. And now, when I try to go back to court, they say res judicata.
right, meaning it's already decided, right?
So
I,
now he has 4 CPS indications and still
does he have
has
a fair,
custody.
does he have a fair hearing coming up, or how's that?
I am not privy to any of that.
Yeah, I mean, that would be a really good question if you could get the answer to, because, that's a hearing where he has to defend his indications, right? And, um, they have an obligation, in theory, CPS has an obligation to really make sure that it's presenting all of the evidence against him that they've marshaled. I'm I but I feel like, again, it happens under a cloak of darkness. It's not like the public's invited to these hearings. It's not like you're being invited to this hearing, and you just don't know what's going on. And I think that's another huge problem, the lack of transparency, around a lot of this processing. There's an ALJ, as you probably know, who will preside over it. There will be a written opinion potentially, but this won't be public. That won't be something that anyone will really hear about, except whether he, unless he wishes other people to hear about it.
Right. And I've come to find out not only is my ex a former attorney for Niagara County CPS, but also he filed Chapter 7 bankruptcy, and his bankruptcy attorney is also a part time Niagara County CPS attorney. So he has him in the mix, also helping him out, ensuring that the kids stay with him instead of come to me.
Well, you said it earlier. I mean, I think the biggest issue is conflicts of interest, and I see this in so many other industries, of course. As an attorney, you see it everywhere, right? But because this area, family law, is not patrolled, monitored, whatever the word is, the way you would see it, say, by like the SEC or some oversight body, it's the Wild West when it comes to conflicts of interest.
Lord of Flies.
It's Lord of Flies. It was William Golding. I mean, that's exactly right. And, how do you, and, most, in most industries where we have oversight, there are disclosure rules, right? You have to disclose, I have an affiliation with this person or that person or whatever. That's not being done in family law.
Not only, but not, there's the disclosure laws, right? And the disclosure, the attorney ethics in New York State is the disclosure is supposed to be in writing, and then you get a waiver for conflict of interest, right? But the loophole everyone uses is that it's determined to be a conflict of interest if a reasonable attorney would see it as so, and then define reasonable attorney. And so there you have, my children's AFC representing my children, even though he hired my ex for over a decade to do work for him.
Yeah, I mean, that to me is very troubling, the way you presented that. I would really wanna be looking at the, code of ethics that applies to see whether there is a violation. I mean, you can always use the grievance process,
Did
uh,
it?
and I know I I'm sorry, I'm laughing. I don't know that I have a lot of faith in that process, and I'll tell you why. Um, that process basically said in many instances will say, we're not gonna make a determination. We're gonna wait for the court
Court.
to make a
Right.
determination. And
You
you
know,
say, "Wait a second, isn't this your job? Like, shouldn't you be doing this? Why would the court be handling this?" Right? And it's frustrating because, they have the ability to do far more than the court does. They can issue subpoenas, they can have interviews, there's so much they can do, and the court can't. So what is going on there? Why are they not using all of the weapons, all of the tools in their toolbox to
well,
look at.
what is the Attorney Grievance Committee? Because I'll tell you why. If you really read in New York State who the authority is on the attorney grievance process, it's not the grievance committee, it's the appellate court. They're the authority on attorney grievance. So it almost seems to me like the attorney grievance people are like rent-a-cops. They're not the real people. They kind of go through things and filter what they want to send to the appellate court. But the appellate court is the overriding authority, and you can write motions to the appellate court. Not even an attorney can write motions to the appellate court. So why are we going through this process with the grievance committee? What are they, and why do we even bother using them?
Stacey, are you in the fourth department?
Yeah.
Fourth, okay. So I'm not sure how it works up there. I'm in the second department and also the first, where the way I believe it works is that you initially present a complaint to that committee, and they're staffed by attorneys and investigators. And then you're right, there's some sort of appellate division oversight, and I'm not quite sure where that kicks in. Sometimes it doesn't kick in at all because remember the way it typically works is that the lawyer may not even be required to respond to your complaint. If it doesn't rise to a certain level, the lawyer won't even know about it. The committee will just say, "Sorry, this is ridiculous. Goodbye." It's not common that the complaint actually goes to the next level, which is that it then it's then forwarded to the subject attorney, and that attorney is required to now respond to the complaint against him. That's an unusual thing. So it's there's not that's another example. There's not much transparency around the process, right? We don't know what happens. These are so confidential. The judiciary law, section 9010 says that when you file a grievance against an attorney in New York State, it's sealed. The documents are sealed. It's private. You don't know anything. No one knows anything except for the members of the committee and the subject attorney potentially. That's it.
Which is unfair because um, there's that rule that, if you're emailing your attorney, you don't carbon copy anybody else because then that's a waiver of your confidentiality.
Right.
But when a judge speaks on record and violates the confidentiality of the process and takes it and retaliates on someone who complained, that's not viewed as a waiver of their confidentiality and their grievance process. But it should be, because if it happens to us, if we just simply email someone and carbon copy them, why doesn't the same apply to judges and attorneys when they're being investigated?
Yeah. I mean, I think it's a mushy area, unfortunately. There's a case, I can't remember the name of it. They just came out of actually the Southern District of New York, which a bunch of professors were complaining about district attorney prosecutors in the Manhattan DA's office, and they publicized their grievance against these prosecutors, and they were taken to task for that. And there was some commentary in the judge's decision that, well, maybe the judiciary law is unconstitutional because it shouldn't be that, this is a confidential process. Why wouldn't the public, if there's a public interest, why wouldn't the public be allowed to know what's going
Right.
on?
Right. That's the New York Public Officers Law too, right? Where as taxpayers, we should be informed about how our money is performing. And I think that's Article 6 of the New York Public Officers Law. Um, but yeah, but these are, sorry, Catherine, but these are laws made by lawyers for lawyers.
I'm with you, Stacey, and it's disturbing. Like it really is. And I think the idea of transparency. I mean, I could write a 20-page article about how we need transparency in all of family court. I mean, why do we not have the public? Why don't they have the ability to attend? How do we avoid a star chamber result if we close it off to everybody? And you know, orders are not ever widely known. I think we were doing ourselves such a tremendous disservice by having all of this happen in a cloak of darkness.
Have
And
you have you ever done court watching yourself?
I have done that, and and I've had people court watch on my behalf. And I will say my current judge has been permitting members of the public in the courtroom, which I'm really, really happy about. She seems to understand that element. And look, while we're on this topic, it is not an automatic rule, as some judges seem to think in New York State, that, well, if we're going to talk about the children, that means that the courtroom has to be closed. It's absolutely not the case. There has to be a kind of weighing of the risks versus the public's interest, and there has to be specific findings on the record before a judge is permitted to simply close the courtroom.
Right.
This issue was litigated in Christy Brinkley's case, about a decade ago or whenever it was, and the attorney for the children argued that the entire courtroom should be sealed. We can't have anybody here. And the judge said, no, that's not right. No, there are serious issues that affect the public, and this is the default position is courtrooms are open to the public.
Right. It's constitutional. It's the First
Right.
Amendment, and in New York State, it's the Uniform Rules of Family Court, Section 205.4, and there you'll find the rules about who can be present and who can be excluded. But it's pretty tight. It's not as willy-nilly. Like you said, judges thought they could just say confidentiality and get out. No, they do have to stipulate a reason to the record. That's in there. In New York State, it's limited to the seating. So I don't know who's going to get crafty and put a half a seat in there, you know.
Right.
But, even arguably, right, these rules were written when there wasn't virtual appearances. And it says the attendance is limited to seating, and arguably virtual court watching then makes everyone, to have the right in seating is now unlimited.
Exactly.
But then you see judges, oh, IT problems. We didn't let you in. It was IT problems.
Yeah, or they say, well, we're not sure who's recording, and there's a prohibition on recording, so we can't have this open to Zoom because somebody could be recording and we don't know who that is. And again, why are the judges and the judiciary, why are they worried about who's recording?
Well, Catherine, I know you've done appeals, and I know I've beat this because I've watched you with your appeals, right? Because the appellate courts, all of them in New York State, I believe, regardless of department, I think they all do live webcasting of oral arguments for appeals. Yep. So if recording court appearances because there's kids' names in there, then what's the appellate court doing?
I hear you. And I question how that rule came into existence and how it's being invoked. And, I've been in a situation where a judge accused me of trying to record a proceeding. And I mean, it was just bizarre. I don't know what gave him that thought in the first place, but it seemed to me that he was more interested in making sure that I didn't capture the tone of his comments to me, and I think that was really the main gist behind it.
I actually did. I don't advise this to anybody, but I did actually record a judge once who held a hearing that was off the record. Um, but I was very cautious in doing it because there there's a judiciary law that a judge may not punish as a contempt the attempt to produce a full and accurate record of a hearing. And
Mm,
since he did it off the record, I was protected. And in 42 USC 1983 gives you the right to vigorously defend your constitutional rights, and having an accurate record is a due process right.
right.
Um, but they're not happy with me because I didn't.
Yeah,
But it was necessary because when that's the most critical time to have a record preserved when they're doing things that are off the record, because that is when these people who have all their conflict of interest are doing their dirty and they know it's off the record.
that's a great
So
point. Yeah, I mean, I think that's a really good point, and I think I had this conversation just recently with a new, mom to her divorce action, and she kept, telling me all her conferences were happening off the record, attorneys only, off the record, attorneys only, and I said, "Why are you agreeing to that? Why?" And she didn't really know that she had the ability to say no to that. You have the ability to say no to off the records. If you want a court reporter present, you should ask for one. If you don't want to have an attorneys only conference where you're kicked into the hallway and you have to wait while your attorney goes in and says something and you don't know what they're saying, um, don't agree to an attorneys only conference. You know,
that's yeah, whenever anyone reaches out to me, that's one of the first things I tell them, because it's actually very commonplace here that the judges try to get away with doing that. Is no, no, you want everything on the record. In all fairness to the parties, on the record. They do that a lot here. And just that one piece of advice can revolutionize a case.
yeah, I mean, it takes away the ability to just, have the attorneys kind of collude or negotiate and then not express what you want them to say and then come out. This I mean, the same thing happened to me in my very, very first court appearance. I wasn't expecting it. And I was presented with a proposed order, a stipulation, and I said, "Where did this come from?" "Oh, we've been negotiating this for the last 3 hours. Here, you've got to sign, you've got to sign." And then it becomes kind of coercive, right? Yeah, that's the other thing. You start to feel bad, like, well, they went in there and they were talking for 2 hours about me, and it's time to go home, and I'm tired. And the next thing you know, you're signing some document that you wish you had not signed, and
Right.
you didn't get the benefit of hearing what was said about you or about what your lawyer was saying on your behalf, or it's just a real opportunity miss, I think, to give away that right.
I'll even take that one step further. Every time I hear people saying that everything in court is happening off the record, um, I immediately question the intent of their own attorney.
Right.
Because why isn't their attorney, who's supposed to be zealously arguing for them, why isn't their own attorney telling them that you really should be there?
Yeah, I agree, Stacy, and I that troubles me a lot. And it makes you wonder if the goal is not to express the client's wishes, but instead to just get this over with, get a result. It doesn't matter if your own client is compromised. And that's, I find, just antithetical really to the practice of law.
Right. And then there's no record of anything that was ever said. And then how do you have an appeal from all these orders?
You
And it just
can't.
makes things more airtight for the attorneys and compromises the client.
That's another really good point, which is that, you know, I don't know that people get this, and I'll just say it, maybe they do, but when there's a stipulation and you sign that stipulation, you're gonna have a hard time appealing that document, right? That's not an order that you contested. That's not an order you objected to. You now agreed. So, whether it gets so ordered, it looks like an order, but if you agreed to it as a stipulation, that's really different from an order that is being imposed upon you that you have the right of appeal from. And, you know, I say that no, as an attorney, of course, I know that, but I don't think a lot of people necessarily get that point.
Yeah, because it's not an order resulting from judicial error.
Right. It's right. It's you're going to have to argue, you know, coercion or duress or mistake or, you know, those are hard standards to meet if you've made the agreement initially. I mean, the same thing applies to a final custody settlement, right? That, you know, if you've agreed to all these terms later, it will be harder to try to undo those terms.
Right. And then why isn't the attorney informing their client that a consent agreement is much harder to get out from than a order from the court?
That's right. That's a great point. And yeah, I don't have an answer for you on that one, but I think you're right. It's not being said widely.
So, if you have any advice after all your experiences to help people who are dealing with CPS in the courts, what's your number one advice that you've learned and wish you knew before you started?
Um, you know, I guess I'll just say, obviously, I'm not giving advice on any particular case. I can't do that, even though I'm a lawyer. My advice is more experiential, and it goes something like this: if you feel in your gut that something is off, really explore that. Don't assume that this system is working and everybody's got the best interests at heart and they're doing their jobs diligently. I was so let down by this system, I can't even tell you. You know, it's like walking into a doctor's office and you see the white coat and you say, "Oh my gosh, okay, well, you know, whatever the doctor says, I mean, that's it, you know." Get the second opinion, think it through. Um, Decide whether it makes sense to you. Talk to other mothers, talk to other fathers, talk to people in your network, and don't sign a document that you haven't fully read and are fully comfortable with.
Very, very, very wise words, Catherine. Very, very wise words.
I hope they
Thank
can help
you.
everybody,
Yeah.
Stacy. Thank
Some
you.
some people some people tell me that intuition is God speaking to you, and um, and yes, that's one of my mistakes that I made even from before I got married. I'll say. Um, is I you should listen to your intuition. It's a gift. And if something doesn't feel right, yes, explore it. And I say that too, even about conflict of interest. If you're a reasonable person and you're grounded in your thinking, and some result is shocking, like your daughter ran away and they're forcing her to go back to where she complained about, that doesn't make sense to any reasonable person. You don't even have to be educated to know, that research shows that running away comes from a bad home. It's your intuition tells you, your common sense tells you. And if things are going opposite what you think they should be doing, then you need to scour your case for conflict of interest also to find out what are the motives, what are the ulterior motives that they look past this and put your child back into that environment.
Well said, Stacy. Yep.
Yeah. Well, all my love to you, Catherine. Thank you for coming on. Thanks for all your wisdom. Thanks for sharing your story. Hopefully someday this will be a better situation by exposing these injustices of the system and that people become more and more involved in our government and watching what's happening in the courts.
Well, thank you for having me on, and thank you for the good work you are doing to help other people like us.
Oh, well, thank you. You have a great day.
Good night.
Good night, hon. Thank you.
Bye.